Hi, everybody. Thank you for tuning in today. I'm going to be talking to you today about estate planning tips that gives us peace of mind when making decisions for a child with special needs that becomes an adult. But first, I just wanted to share that yesterday, Governor Whitmer signed a new emergency and disaster declaration that's going to extend till May 22nd. This does not mean that the stay-at-home order will automatically last through May. This just means that the governor would have to sign a new executive order to extend the stay-at-home order if, in fact, she does do that. The total number of COVID cases today have reached 41,379 in Michigan. Number of deaths, it's 3,789. But as of April 24th, there have been 8,342 people that we've covered from this pandemic. Now, while all estate planning is important, it takes a greater significance when you have a child with special needs. In most states, including Michigan, when a child reaches 18, he or she is presumed to have the decision-making capacity, and that's when the parent's legal authority ends. But parents of children with special needs have a lot of options, and each with advantages and disadvantages, depending on the situation, to establish a new legal authority to continue making those important decisions for your children. I briefly talked about some of the things that can be done last week, but I wanted to divulge in further this week. So, some kids with profound learning disabilities might need financial support for the rest of their lives. But how can you plan so far into the future when there are so many pressures to deal with right now? One thing is certain. Whatever planning you do now is sure to make a difference. I'm going to discuss some of the ways to ensure a more secure future for your child. You know, it's hard. It's hard not to worry about how your child is going to manage if you are not around to help support him or her in the future. That is why long-term financial planning can help relieve some of that stress and let you focus on meeting your child's needs right now. And some of the difficulty of estate planning when it comes to our children with special needs is knowing what type of care they need or what type of government benefits will they be eligible for when they turn 18. Some people feel overwhelmed about special needs planning because they don't have a clear picture of what their children will need in the future, and that's okay. But parents of special needs children must be concerned about ensuring that their medical and financial decisions will continue to be made in their child's best interest once their child turns 18, which in Michigan is the legal age of capacity. And in order to do that, there's a lot of factors that need to be considered. One, if the child is incapable of making personal or financial decisions once he or she becomes an adult, you're going to have a parent or anyone else that is an adult that is not incapacitated and does not have a significant conflict of interest. So with this person, I talked about this last week, they can ask the court to be appointed a guardian or a conservator. That's what a lot of people do. But here's the downside, is that a guardianship or a conservatorship requires a whole court process. It can be really time consuming, costly, emotionally draining for the person, not only for the person with special needs, but for their family. And in order to protect against abuse of powers in a conservatorship or a guardianship, the individual who is the object of the guardianship or conservatorship, the child, is usually represented by his or her own attorney. And then the court will determine if the person that's disabled is incapable of making his or her own decisions. So, in cases where someone is appointed to make financial decisions, the court might require that person to become bonded, file annual financial statements, and request the court's permission before dealing with the property of the person with special needs. This is meant to increase oversight and protection, but it also decreases family control. Now, there are ways to avoid that time and expense of the guardianship or conservatorship process while accomplishing the same basic goals. Now, if you have a child with special needs, it's important to start reviewing your planning options to by discussing your child's health, capabilities, and prognosis with an attorney. And then you can tailor a plan that's right for your child and allowing as much flexibility as possible. Now, if the person with special needs has a sufficient capacity to understand, he or she can appoint their own agent using a durable power of attorney over medical or financial matters or both. That's the topic that we talked about last week. And depending on the type of power of attorney, the agent will have the authority to make financial and property decisions or medical and personal decisions on behalf of the special needs adult without any court intervention or direct oversight or anything like that. This doesn't have to be a parent or a sibling. It could be anyone of their choosing. It could be a friend. It could be, a mentor. It could be anybody, anyone that they trust. Now, for example, if the child or adult child receives either SSI, which is supplemental security income, or SSDI, which is Social Security Disability Insurance, and can't manage the income themselves, then the SSA, which is the Social Security Administration, allows another person who is titled as a representative payee to receive those funds to use on your child's behalf. However, this option also requires a filing of an annual report showing how the money was used. Now, estate planning for special needs. It can be really challenging. And you might think the best way to provide extra financial support for your child in adulthood is to start a bank account in their name. But that might not always be the case. For example, assets that are greater of amounts of $2,000 in your child's name, regardless of his or her age, might make him ineligible for government programs such as Medicaid and or supplemental security income. So another option for parents to consider is establishing what is called a special needs trust. And before you consider having an attorney draft a special needs trust, here are the things that you need to think about first. First, you should learn about Medicaid and supplemental security income. Second, see if an inheritance will keep your child from being eligible. Make sure anyone leaving your child money is going to be directing it to the trust. Decide whether to create a trust while you're living or as a part of your will. Find out different types of special needs trust and how it will affect your taxes by consulting a CPA. Select an informed trustee. It can be an individual or a financial institution or both. But always be sure to carefully discuss with a qualified attorney before you try and set any trust up, because they can be very complicated. A special needs trust can pay for a number of things that the government programs might not cover. For example, education, tuition, entertainment, vacations, computer equipment. And if done correctly and properly, a special needs trust can help your child's needs without keeping him or her from getting government benefits that they do deserve. Imagine $2,000. It doesn't go that very far. And then the government sees that money and says, no, this special needs a child or adult doesn't need government assistance. And then they're at a loss. And then what do? So you can set up a special needs trust while you're alive, or you can set one up as a part of your will or a testament. A special needs trust is often used, for example, as I was saying, if there's a strong chance that your child will receive government benefits. And the goal here is to supplement, but not to supplant the government benefits that the child will receive. The trust allows a person with special needs to shield assets for certain purposes while maintaining eligibility to receive SSI and Medicaid benefits. So the trust must be drafted carefully so the child does not become ineligible for those government benefits. The trustee in the situation will then invest and manage the trust assets, and this will usually avoid the need for a financial guardian or conservator. The government benefits that the child will receive provide for basic needs like a place to live, or food. But setting up a special needs trust is going to provide for the extras that the government benefits don't provide for. That's like a trip to an amusement park or the movies, or anything like that. Hopefully when we are over this pandemic and we resume to our new normal. So what about those people that have sufficient assets and don't or prefer their child not to receive any government benefits at all? In this type of situation, those individuals will set aside a sufficient amount to cover all the child's living expenses in a trust. This will be a large sum of money or other assets like an investment property or bonds, securities, things like that, other types of assets. And this is usually the case when parents are not concerned with their child receiving government benefits. And another thing is that a trust can be also crafted to be discretionary. So, for example, if the parents want to provide certain assets that will cover, those extra things that the government would not cover, it could be like a hybrid. They could use that too. So what they'll do is, we can set up a trust that is called a discretionary trust, and that will distribute the income and the principal at the trustee's discretion for the benefit of the child throughout the child's life. And if the parents cannot predict at all whether a child will be eligible for any government benefit, another option is for parents to give their current trustees the ability to create a special separate trust at the time of their of the parent's death. And that way, if the child at that time is receiving benefits from the government, then the trustee will have the ability to create a trust at that time with the goal of preserving the child's benefits. It's very important. And one thing to know is that these trusts can be funded now, meaning that the parents establish the trust and then transfer the cash or other assets to it, or the trust can be just created now and left empty until a parent dies. And at that point, money can just flow into the trust from the parent's estate or from another trust that they'd establish or from a life insurance policy or another, you know, type of policy that, you know, an investment account or anything like that that would automate, or like a 401k or an IRA, anything that you know the parent has established as an investment asset that would, you know, go directly to the child after their death, can be used in a special needs trust can be used for that purpose. There are some situations where, although very rare, where some parents choose not to create a trust for their child and to disinherit their child completely. And the rationale is that the child will be 100% supported by government benefits. In my opinion, this is somewhat of a cold approach and not one that I don't think any of my clients would actually embrace. Um, I've found that it's actually the reverse happens when a person with child needs, and the parents often feel that they need to do everything and they need to actually overcompensate by leaving as much money as they possibly can so that their child is taken care of um, in the same manner, or you know, that's satisfactory to his or her parents. Some parents will also adopt, I talked about this just a few seconds ago, a hybrid approach, um, where they disinherit the special needs child, but they'll leave more assets to their other children, if they do have other children, that are not incapacitated, with the understanding that the other children are going to care for the special needs child. I don't advise this for a number of reasons. One, the sibling has no legal obligation to care for his or her special needs sibling. It's only a moral obligation. Second, if the child gets divorced, for example, um, if not protected beforehand, those assets can be susceptible to a division upon a divorce. Third, or the assets are susceptible to a creditor claim if the child is sued by a creditor. You want to do everything possible to protect those assets if you're going to be leaving any at all for your special needs child. You know, it might be the case where it's necessary for you to keep control over financial or healthcare decisions even after your child becomes a legal adult at 18. And that there's no way that, you know, your child can make any decisions on their own, and they, you know, it's impossible to go through a route of estate planning or a power of attorney for your child. And if this might be, you know, the case for a lot of people, and If it is, then you would have to apply for a guardianship or a conservatorship. So that's something to keep in mind. But a lot of you might be thinking, but where do I start? All you gave me all this information, but where do I start? How do I, you know, do this? So on our website, we're going to be putting on some checklists to see, for you to take a look at and to see, all the things that you should be thinking about. But especially for estate planning for a child with special needs, I know it could be very challenging and very overwhelming. You're doing everything in your power already to help your child become independent one day. And despite everything you're doing, you might have some concerns and whether or not your child will be able to financially support himself. And it's very hard to avoid that question. What will happen after my death? What's going to happen to our kids? So you can take some steps now to prepare for that day by putting together what is called a letter of intent. It is not legally binding, but it's a start. It's a start. This document would help you spell out your wishes for your child. And it might be, helpful for friends or family or future caregivers, or simply just as a start to prepare for that future estate plan for your child. A couple things that you should consider. Number one, carefully consider what kind of life you would like for your child. Create a letter of intent for future caregivers stating your desires. Include your child's medical history and personal care needs. Share this document with your friends and family or the people that you trust. And review it regularly and update it as you need to. What should you include in this letter? A couple things that people include are, hopes and dreams for a child's future, whether that's, education, financial, like a personal goals, anything like that. Preferred living arrangements, your child's medical history, the personal care needs of your child, recreation, social, community interests. Maybe they love, basketball or, you know, I don't know, anything that they love. Maybe they love baking. Maybe, there's a baking class that, you want to make sure that your kid's going to be able to go to. So there's a lot of things that you could include. And it's all about the hopes and dreams of your child's future. So once you've crafted this document, share it. You can even put it on a Google document, and you can, regularly review it and update it as needed. And, all your friends and family that you trust will have access to it. Remember, it's not legally binding and it's just a start. Remember this, everybody is different. Every individual has a unique plan. So having a plan that is carefully crafted for your own individual needs and the own individual needs for your special needs child is very important. It could be a single document or even a combination of these approaches, as I talked about, a hybrid. Any approach is carefully crafted to best fit your own particular situation. Some of the factors to consider is the nature of your child's special needs, the source and type of your child's assets, and whether your child has the sufficient capacity to understand his or her choices. It's important to get a plan in place that allows for flexibility without that court stringent policies, costly, expensive, and taking away that flexibility from the family. All these things will afford you a peace of mind. I'm going to check now if anyone has any questions. Hi, Brenda. Thanks, Beth. Well, next week I'm going to be talking about estate planning and advanced directives when it comes to special needs children and education, and what parents can do in for the future education planning needs of their children. Thank you for tuning in. If you have any questions, please put it in the comments. I will answer them. You can direct message us. We're here. We're here to help. And I look forward to speaking to all of you next week. Thank you.